college. I initially got involved in the campaign because I had several friends who'd taken Maggie's on constitutional law at Dartmouth. They loved it and told me to get involved because Maggie was a special teacher. As part of the team, I've seen that she is certainly a special teacher, but more than that, a really special candidate and person. I'm inspired by her, and I hope you see this tonight and that you learn something new. We are so excited to have former New Hampshire Supreme Court Chief Justice John Broderick here with us tonight to give an introduction to this evening's topic and to Maggie. John, I'll pass it off to you, if you can hear.
Great, thank you. Thank goodness there's no videotape of my entrance on the screen. It wasn't pretty, but I made it. First of all, let me thank everyone for joining tonight and to listen to Maggie, who I've come to know over the last 4 years. She's an extraordinary person with an extraordinary resume, obviously, but more importantly, she's a solutions-based person who has experience that most people would never have. She has a phenomenal judgment and profound decency. In the 52 years I've been in New Hampshire, I've never met anybody in public life quite like her. And she deserves our support. She has mine. I've spent my entire life as a lawyer, as a trial lawyer, as a member of the Supreme Court of our state for 15 years, as dean of our law school at UNH. And over that time, I think it's pretty clear that I've had a reverence for the law and the judicial system. I've always admired our Supreme Court, even when I didn't agree with them. In the events of the last 3 or 4 years, I've come to question that.
Recording in progress.
Which, as a lawyer and a former judge, makes me very sad, but I'm being very honest. And the Supreme Court of the United States used to be perhaps the most respected institution in American life. It's not today, and it's not an accident. I wrote an op-ed in the paper recently about it. It was published in the Bar News today on this very topic. I think we are at a crossroads of sorts in our country, and we need people like Maggie Goodlander who's willing to step forward with all of her credentials. It's not easy to run for public office, but it's really important, more so now than ever. Okay. So tonight, I hope that we'll have a free and frank discussion about the Supreme Court of the United States and the decisions they issue, which govern all of our lives. But I must confess to all of you tonight that I never thought after 49 years, with a recognized constitutional right for American women and their families, that our court would take it away. I'm still shocked by that. Can you imagine that 49 years after Brown versus Board of Education, Supreme Court of the United States said we were wrong about that, be a civil war in this country? I'm profoundly concerned about what's happening there. I'm concerned about the ethics I see in that institution. It pains me to say that, but I'm concerned about it. And I think we need leaders in Washington, younger leaders in Washington, like Maggie Goodlander, who's a profound intellect, a really good listener, and with first-rate judgment and character. So I'm here tonight like you are. I want to hear what she has to say. I hope you'll be forthcoming with questions. But in any event, it's an important night. And I hope at the end of this, if you're as impressed with Maggie Goodlander as I am, that you'll do all you can to get her elected to the United States Congress. You'll never regret that if you do it. Anyway, thank you. A pleasure to be with all of you tonight.
Thank you so much, John. Now I want to pass the virtual mic on to Megan Carpenter. Megan, thank you so much for being here.
Thank you so much for having me. And it is such a pleasure and a joy to be here and talk with Maggie this evening. I want to thank Chief Justice and Dean Broderick for that lovely intro and the passion that he has for Maggie as a candidate. I want to welcome everyone here this evening. As Sophie mentioned, I'm Megan Carpenter. I'm Dean of UNH Franklin Pierce School of Law, where Maggie has taught for years. But I also want to be very clear, I'm here in my personal capacity as a citizen who cares deeply for this country and am equally concerned about the direction that we are going and the rule of law. I will share with you that the first time I met Maggie, I can remember it. There's sometimes you meet people where it just crystallizes for you. You feel like you're meeting. It's a conversation that becomes something special. And we talked about her enthusiasm for civil procedure, which is the body of law that regulates the process by which we kind of uphold the basic rule of law. And I frankly find it to be one of the most boring areas of the law. But Maggie's enthusiasm and energy were so evident in that first discussion. And I reflect upon that now because as Maggie has taught with us at the law school, including in the area of constitutional law, I cannot think of two more critical areas of law for us right now: how we interpret our Constitution and how we uphold our democracy and the rule of law. I've followed Maggie's work in the Supreme Court, the Department of Justice, the White House, and also very importantly here in New Hampshire, because one thing that has always come through her work is her commitment to this state and to the people here. And as I think about what we need as a country going forward, I think it's probably the thought bubble above all of our heads right now. We really need people who bring that kind of energy and enthusiasm for law, for the heart of our democracy, and really for our people. And to me, Maggie Goodlander exemplifies those qualities and what we need in a new generation of strong leadership in the United States. So I am delighted that she's here with us this evening, delighted to spend some time with her virtually and with all of you. So here's how it's going to go. I'll ask her to talk a little bit at the beginning just about what's at stake for all of us in this election. And then I'll ask her some questions about the Supreme Court, the state of our democracy. And then I'll ask her some questions from you. So if you think of questions along the way that you would like to ask Maggie, please just put them in chat and we'll get to what we can. So Maggie, let me turn it over to you. Thank you so much for joining us this evening.
Well, thank you, Megan and Chief Justice Broderick and Sophie and all of you here tonight. I'm really grateful to be in conversation with you. Look, this is
Your number.
this is an anxious time for our country. But I can tell you, I just want to begin by saying that this, for me, the past 60 plus days that I've been on the campaign trail have been some of the most energizing and optimistic of my life. It has been the best job interview I've had ever, and this is a job interview, as it should be in a democracy. There's no doubt who the boss is, and that's what excites me about this opportunity that I've had to participate in our democracy in a way that I have never had the opportunity to do before. Although I have served in all three branches of our government, Article 1 has always been my favorite, but tonight we're here to talk about Article 3. But let me just say a few words at the outset. For those of you who I don't know yet, and look forward to meeting, I was born on Election Day, and it's an amazing story because my mom, Betty, she was serving in the State House at the time, and she went into labor and she went directly to the polling place to vote because that's what we do in New Hampshire. And there's nowhere in the world that does democracy better than we do. No one who believes in freedom more than we do in the Granite State. And democracy and freedom, it's not an understatement to say, I wish it were, are genuinely on the ballot this fall. And I got into this race because I really believe that this is a job. The very first institution that our Constitution creates is the People's House. It was the most democratic institution the world had ever known when it came into being. And I think if we give up on the People's House, we give up on the American Constitutional Project. And so we need people who are ready on day one to really deliver for this district and for our country, because day 3 on this job is January 6th, and we have so much work to do. When I say democracy's on the ballot, what I mean is, protecting democracy is about at its core accountability, I think. And I was really proud to serve with an incredible group of constitutional lawyers, scholars and practitioners and investigators. We brought the first impeachment case against former President Donald Trump. It wasn't the last one, but our whole case was really rooted in one of the core principles of the Constitution that I know we're going to talk about tonight, Megan, which is the idea that no politician is above the law. It is so core to the American constitutional project and the experiment that we're undertaking. And it really is an experiment. And I believe it's an experiment that Congress has got to play a central role in, because for too long, the Supreme Court has had a monopoly on the Constitution, and it's done a lot of damage to our country. And so this is just a point I want to make tonight to all of you. I love teaching constitutional law. It's been one of the most extraordinary things that I've ever been able to do. And I love teaching it here at UNH, and I love teaching it at Dartmouth, because this is what the project depends on. And I've said to people along the way on the campaign trail over the last 60 days that if you're ever feeling anxious or down, just pick up your copy of the Constitution, because it was written for you. It was written to be read by all Americans, and it only takes about 30 minutes. So I recommend it to all of you, because every time I do it, and I did this afternoon in excitement for our conversation, I learned something new. And this is what the project's all about. So democracy is on the ballot. Freedom is on the ballot. We're going to talk about all these things tonight, Megan, and I'm just grateful to you for being in conversation with me on my favorite topic. Constitution,
Well,
Supreme Court, but we'll talk about that too.
yeah, well, thank you so much, Maggie. And so let's start kind of when you clerked for the Supreme Court. Tell us what that was like and what your experience was like at that time.
Well, in some ways, the federal judiciary operates on each federal judge gets 4 employees, and each employee has a 1-year job term limit. So it's a very kind of structured workforce where it's 1 year, and each judge has four law clerks. So in some ways, to explain my experience on the Supreme Court, which coincided with the first year of the Trump administration, I kind of have to explain what I did the year before that, which is I clerked for then Chief Judge Merrick Garland on the DC Circuit Court of Appeals, the Federal Court of Appeals, just down the street from the Supreme Court. And I began working for Merrick Garland when his nomination was pending before the Senate. And so my days with him were spent preparing for a confirmation hearing that he never had the opportunity to participate in. We read every single Supreme Court case. He was the most prepared judicial nominee possibly in American history, and he never got a hearing. And watching that episode transpire, as someone who believes deeply in Congress and who began my career in the Senate, it was a truly heartbreaking experience to see what happened. And, what happened was the Supreme Court was stolen from the American people in a real sense. And I don't say that to be inflammatory in any sense. I say it because I think it's important that we say what's true and what's real and what happened. And that is what happened. The course of history was changed. The composition of the court the year that I clerked, and I was incredibly lucky. I clerked for Justice Stephen Breyer, who was like Merrick Garland. Merrick Garland is a person who is so incredibly committed to the rule of law. He's, a judge's judge, for better or for worse these days, but he's a judge's judge. And Justice Breyer, and he was a judge, by the way, who had previously worked at the Justice Department and is obviously there now. But he came from an experience with a background in the executive branch. Justice Breyer began his career and had his formative years in the United States Senate and Congress. And he's a person, I learned so much from him. He's the most optimistic person I've ever met. One of the most brilliant and optimistic. And he had worked for Senator Ted Kennedy, who I think about every single day, because Senator Kennedy had this way of thinking. He would say, look, we've always got to find the 30%, the 30% that we can find agreement with, no matter who we're sitting across the table from. And that's really been a principle I've tried to apply in the work I've done. So I learned a whole lot from Justice Breyer and from then Judge Garland. But the experience of working on the court was really colored by what I felt had happened, which is that the court had been stolen from the American people. And it was a difficult year. You know, it's a 1-year experience. And the year I clerked, there were more 5-4 decisions than had ever happened in, decades prior. It was an incredibly divided court. And at that time, we still had Justice Kennedy. So we still had hope, which is to say we still had hope. But some of we heard a lot of really big cases that were decided 5-4, and we were in dissent in all of them. It was, a year in which I saw firsthand just how surprising it is that there have not been more guardrails on how the Supreme Court does its work. And, I know that's something that I've been encouraged to hear and to be asked about and to be in conversation with people about every single day on the campaign trail. And it's a good thing because we need more guardrails.
Well, speaking of guardrails, that's a good segue to asking, I mean, there's some rumors right now about, that Biden is going to propose reforms to the Supreme Court. I think Dahlia Lithwick wrote something in Slate today, about these reforms as well, recognizing that, we need a lot of things to happen that in order to put any of that in place. Whether it's, like the presidency and a filibuster-proof majority in the Senate and the House and everything. But as thinking about the kinds of reforms that might come forward, I was just wondering what your thoughts are on reforms in the Supreme Court, and what would you support?
I think what Justice Broderick said at the outset is absolutely right, that the Supreme Court used to be one of the most, if not the most trusted institution in American public life. And today it is one of the least trusted. 70% of Americans believe that the Supreme Court is going to make decisions on the basis of partisan ideology. And that is a huge problem for the rule of law. This experiment, and if you listened to what Justice Breyer said when he retired, when he announced his retirement at the White House, he talked about what I think is so true, that this is an experiment that depends upon the faith of the people. And if we have a country in which 70% of Americans really don't have faith in this court, it is an existential risk to the rule of law. We have to have faith in our court system. And so how do we build that faith? I mean, I think, look, when you read the Constitution, this is why I encourage everyone to do it, because there's a lot of debate about, which reforms are constitutional and which aren't. And it's going to be the task of really, and it's a congressional task. I mean, I think it's a wonderful thing that President Biden wants to engage in that. And, he too comes from Congress. So it's entirely appropriate. One thing I teach in my constitutional law class is that the Supreme Court does not have a monopoly on the Constitution. And it certainly doesn't have a monopoly on checking its own power and creating guardrails for itself. So, when you read the Constitution, it says that judges of the Supreme Court and of the inferior courts hold their offices on good behavior, during good behavior. Those are the words the Constitution uses. And so, and I love teaching at Dartmouth because they're not yet lawyers. They're people who come to this document honestly, and just reading the words, it's really hard, I think, to make the case that there's been enough good behavior. There's been a lot of bad behavior from the Supreme Court and its justices. And look, an ethics code should be written by Congress and it should be enforceable, period. I feel really strongly about that because I saw from the inside just how strange and wrong it is for there to be no code for the fox to be guarding the hen house. I think it's an incredibly important first step, and it's one that when you just look at public opinion, the overwhelming majority of Americans believe that in this basic concept that there should be an enforceable code of ethics that applies to Supreme Court justices, just as it does to lower federal court judges. So let's start there. I mean, and then, you think about the next big reform that gets a lot of attention, which is the question of term limits. And I think this one is maybe slightly trickier, but it's one that has got to be considered very carefully because, there is nothing in the text of the Constitution that says there shall be lifetime tenure. It says the judges and the justices hold office on good behavior. And there are different ways to make a constitutional argument. The argument that's made to say they get lifetime tenure protections, period, full stop, is a structural argument about protecting the rule of law and the independence of the judiciary. But, the biggest threat to the rule of law right now is the lack of faith that the American people have in the Supreme Court. And it's really up to Congress and, God willing, a president who can sign proposed legislation into law to come together and to think, look, in this administration, we had a very thorough review of all the possible Supreme Court reforms that Congress and the president could consider together. And term limits the idea of 18-year term limits gets extraordinary support from across the ideological spectrum because it's good government. The Constitution didn't contemplate that anyone would be in office for their entire life. And right now we have, we're on track for Justice Thomas to be the longest serving Supreme Court justice in American history. So that's another one. And, look, the third big reform that gets a lot of attention is whether the size of the court should be reconsidered. And the number 9 is not written into the Constitution, and Congress it's on Congress to really determine what the right size of the court is, what the right composition of the court is. And I think it's hard to think about these reforms in isolation because they've all got to fit together as a package. But my own deeply held view is that it is Congress's responsibility to step up and to think about the full scope of reforms that we're going to need and to bring those reforms swiftly. And that's part of really what brings me to run for this office, because this is something I want to do on day one. I think I hear about it everywhere I go in the district, and I'm eager to hear more from this group tonight.
Thank you so much. There's a lot of ground to cover, but just to kind of follow on with that question, I'll incorporate an audience question, which is thinking about kind of what can the next Congress do to kind of help some of those guardrails to put them in, and how can you play a role as a freshman congresswoman where, we're all thinking that we need this kind of, junior leadership coming in, and yet so much depends on kind of seniority of how long you have been in that position. So how would you think about using your experience to affect change?
One of the things I saw working in the Senate and then in the House over the past years was just, it is a hierarchical structure in some ways in Congress, but actually I saw so many examples of first term, first year, first month, energized members of Congress who were not afraid to get into a Word document and start drafting a bill, and to just do the job, to do the work. So this is how I've always operated. I'm a workhorse. And this is the kind of thing where sometimes there's too much talk sometimes. It's one of they say that the floor of the United States Senate is, it's a deliberative body, but sometimes deliberation gets in the way of actually drafting and getting language. And, I think my experience having worked there as a staffer in both the House and the Senate, I know how the sausage gets made, and it's not always pretty, but what I can tell you is when you've got an energized member of Congress, it can take a small but mighty group to move things forward. And I've had the real privilege of working with many members of the House of Representatives who I hope will be in leadership. And one of them who I just respect so deeply is Hakeem Jeffries, who I had an opportunity to work with during impeachment. And he is an extraordinary leader. He's an extraordinary communicator. And he's a person who I believe will see the opportunities and help to move forward substantive legislation. And look, this is legislation that I believe can get bipartisan support, because here's the deal. I know a lot of people who have spent a lot of years trying to confirm federal judges on the courts, lower and on the Supreme Court. And it's just so evident that we've reached an existential crisis when it comes to faith in that system. And so I believe deeply that sunlight can be the best disinfectant, and the more that the public knows, I give ProPublica a huge amount of credit. It's an incredible news organization that I believe has played a huge role in shining a light on, unfortunately, a lot of the bad behavior we've seen from the Supreme Court. I think members of Congress have an incredibly important role to play in oversight and in amplifying and letting the public know what's happening, because there is strong popular support. We see it in public opinion all the time for these basic reforms, the three in which I just talked about. So what I can tell you is I will get right to work, and I will do the work, because it is existential for our democracy.
Thank you. I want to make sure that to ask, and I'm so curious as to your thought on the Loper-Bright opinion and sort of overturning the Chevron doctrine, giving deference to administrative agencies. I feel like everyone I talk with has either one extreme opinion or the other, and these are all people that are smart and educated lawyers, and it's either this is sort of doom and gloom, and how this decision singularly could really eviscerate large components of the civil service or the administrative bodies that provide so much subject matter expertise in interpreting legislation. But then I equally hear on the other side, people are saying this really isn't going to be that big of a deal. It's only going to come up on these close cases, and then those end up in court anyway. And so, where do you fall, and what are your thoughts about the Loper-Bright decision?
Well, so just to level set, I mean, I love teaching administrative law, and can I just say, Megan, that it is when I was teaching administrative law at UNH Law School as a required course, which I loved, because although it sounds very boring, administrative law is the law of government, and it is so important for anyone in Congress to really understand the administrative state. So when I was teaching administrative law when I first started teaching it 6 years ago, I think, 6 years ago, this was 6 years before the death of Chevron, which is the case that, and the basic idea, just to give everyone a sense of this, because there have been so many bad Supreme Court decisions. It's a very competitive field. For the past 20 years, for the past 20 days, we've had a lot of bad law made, but the idea, what the Supreme Court did in this case was to overturn a doctrine called the Chevron doctrine. And the basic idea, the basic rule behind Chevron was that judges, when they were hearing cases and there was an ambiguous phrase or set of words in a statute, if it could be read one of two ways. You defer to the experts and you listen to the people on the front lines of the fight to enforce federal law. So it's a very simple idea. I'm a big believer in deferring to experts because I believe in facts and I believe in expertise. But federal judges, starting, 10 to 15 years ago, really questioned this doctrine. And it comes down to the problem that we have where, the Supreme Court has for too long felt that it had monopoly on interpreting the Constitution. We see the same challenge when it comes to federal laws. And so to me, that getting rid of this doctrine is a big deal. It's a big problem because it's going to put interpretive power and the fate of so many federal programs and the administration of so many federal statutes into the hands of unelected judges who didn't write the laws and who do have a responsibility for interpreting them, but don't have a monopoly on it. And it's an entirely reasonable doctrine that had strong support from the Supreme Court when it was it first came into being in 1984. But here's what I'd say, as I've read a lot of these decisions, including this one, including the decision on presidential immunity, my first thought is, now that we don't have Chevron, it actually gives Congress no excuse to write laws that are going to be ambiguous in a way that's going to put their fate in the hands of unelected judges. So to me, this is a real opportunity for Congress to step up, to do better at the job of writing laws. And I think part of the challenge and the problem and the reason for Chevron is there are too many members of Congress who are writing these laws or participating in the writing of these laws who have not had the experience that I've had actually enforcing these laws on the front lines, and who also haven't had the experience of trying to interpret these laws from the bench. And so this is why the process of lawmaking is it's important to have members of Congress who have seen how law gets enforced and interpreted, because it makes you much better at writing laws. And what I can tell you from inside the Justice Department for the last, for the 3 years that I was there, we spent a lot of time trying to give Congress our own, on the front end, before they pass laws, our own feedback. And we created really a robust process of giving expert advice on the front end, because everyone has sort of been anticipating the death of Chevron. So my reaction is it is a terrible decision, but it is just another absolute imperative for Congress to get to work and to do a better job. And that's exactly what I want to do.
You mentioned presidential immunity. What do you think of the immunity decision? I think that's coming up in the chat and certainly on my list of things to ask you about.
Yeah, look, there are a couple of really core ideas behind the American Constitution and our whole constitutional project. You read the Declaration of Independence, you read the Constitution, one of the unavoidable principles is that no person is above the law. We have equal justice under law, as the Supreme Court says in the front of its building. This is a core idea. And the idea that the president, because he or she is president, would be above the law is so contrary to, I think, just a basic understanding of how our constitutional system has got to operate. But so, I've read the decision now 3 times, and I plan to read it many more times, because I think, again, this is one where it's up to Congress to pick up the baton from where the Supreme Court left it. And I think that there is a way for Congress to move forward here. It may be that ultimately we need a constitutional amendment, which it wouldn't be the first time that we had a Supreme Court decision that was really bad and damaging to our democracy that is going to require a constitutional amendment. But in the meantime, I think reading the Chief Justice's opinion, and, unfortunately, I think this was a very predictable decision and framework, but it's one that we can work with. So he laid out, this 3-part framework. And and very much in the spirit of Justice Jackson, who had served as Attorney General, served on the Supreme Court, and was the chief prosecutor at Nuremberg. He wrote a decision about presidential power in which he set out a three-part framework that courts and constitutional lawyers have tried to apply in thinking about the constitutionality of various presidential actions. And so this framework was used in the travel ban case. It's a flexible framework that ultimately, I think, leaves a lot of room for Congress to legislate responsibly. And, we have a very long and detailed federal criminal code. We've got federal, if you have a minute, take a look on Twitter. I'm pretty new to Twitter, but I did find this incredible account on Twitter. It's called A Federal Crime a Day, and it details just the most extraordinary. Congress has thought about just about everything that can be addressed by the federal criminal law. But there is no code that applies to the conduct of the president. There are plenty of federal criminal laws that prohibit citizens from taking certain action with respect to the president. But I think in part because we just never had to, this is unprecedented that we've had to think about so much of what Donald Trump has done to America has tested the basic premises of our Constitution, and the Supreme Court has likewise forced us to do that too. But we've never had this code because we've never had to have it, just like we probably didn't have a pressing need to have a code of conduct and ethics that was enforceable against the Supreme Court, although that's a debatable proposition. But what I'd say is Congress really needs to, in the first instance, pick up the baton and craft federal criminal law, because that's the job of Congress. The court does not get to write the laws. That is Congress's job. And it's going to take it's going to take people who really understand how the federal criminal law is enforced and how these laws will be interpreted by the court. But my very strong view is that, once again, Congress has got to pick up the baton, because we cannot let this decision stand. It is just wrong.
One of the questions that's come in through the chat isn't with regard to this particular term, but in the past, with regard to Citizens United, which was a case that gave certain sort of personhood rights to corporations. Would you comment on Citizens United and what you think we should do about that, if anything?
Look, I think, like I said, I mean, it's a very competitive field for the worst Supreme Court decisions in the past several years, past several days. Citizens United is undoubtedly on the short list. To me, when you read the Constitution, we have 27 amendments, and most of them are about the right to vote and about ensuring that in this democracy, and it's because the right to vote is the right from which all other rights flow. In Citizens United, the Supreme Court upended the First Amendment in a way that is so destructive, and that, in addition to the basic proposition that a corporation is a person, which I think in itself has unleashed a lot of damage into American law and American public life, it has run wreckage into our election system. And I believe, look, the law that was at issue in that case, McCain-Feingold, a bipartisan law that really was about protecting the integrity of our system of elections, protecting candidates and voters alike. And so, look, my strong view is that Congress has got to get to work. I think that I'm an optimist. I'm an optimist who worries, but I'm an optimist, and I'm a person who really take seriously that you've got to find the common ground wherever you possibly can. And so I don't say this naively, because I know how hard it is to do that. But I believe we've got to try to find common ground on campaign finance reform and on the whole range of, look, if we can take back the House and keep the White House and keep the Senate at the federal level, we can bring about the golden age of American lawmaking. We have an opportunity to fix a lot of what has been broken, and to advance reforms that I think will do so much for this country. But we're going to have to make the case on a bipartisan basis. And what I can tell you is, as a person who is a citizen and as a person who teaches and practices constitutional law, I've always understood how damaging Citizens United is. I'm not taking a dime of corporate PAC money because I think it's incredibly important that as candidates, we do whatever is in our power. You know, I can't rewrite the law as it is right now, but I can make decisions about how I'm going to proceed as a candidate. And to me, it's an important one. It's connected deeply to the work that I've done at the Justice Department to hold big corporations, monopolies that are making life hard for hardworking people across this state every day. It's all connected in my mind. And I will work with everything I've got to make sure that we can do whatever we possibly can to protect the integrity of our elections.
Maggie, I'm going to ask you one more question about the Supreme Court, and then I want to just focus, give you two questions that are more forward thinking. Reproductive freedom is something that has been really important to you and that you talk about as being central to issues that you care passionately about. What role do you think the courts will or should play, going forward as we deal with issues around reproductive freedom?
You know, I think, look, it's an extraordinary thing that we got the right to vote. Women got the right to vote in this country just a little over 100 years ago, when the 19th Amendment became law. And 2 years ago, I just couldn't agree more with what Justice Broderick said. It's still, to me, it's shocking. And every time I teach the Dobbs decision, every time I read that decision, it is such an inversion of, again, a core constitutional principle that we are all equal under the law, that there is equal justice under the law. The Supreme Court ripped away a fundamental right that I believe is at the core of what we need to ensure gender equality in this country, what we need to protect the most important decisions that a person can make, whether, when, and how to become a parent. And as a person who, you know, my husband, Jake, and I we want to become parents. And it can sometimes feel like here in New Hampshire, we aren't in, you know, the Dobbs decision, you know, is a distant reality. But the truth is, and many of you know this, New Hampshire is the only state in New England that has no constitutional or statutory protections for abortion access. We are an outlier. And, you know, I was clerking on the Supreme Court the year that Roe v. Wade was first really called into question. I was working at the Justice Department the day that the Dobbs decision was handed down. What I can tell you is, looking across this country, chaos and injustice, true injustice ensued. We worked really hard to try to, in the aftermath of that decision, we had been prepared, but you know, chaos really ensued as courts across the country upheld abortion bans that led women to try to get access to reproductive health care across state lines. There was a lot of legal uncertainty because the Dobbs decision didn't give a roadmap to what was really lawful. So we, at the Justice Department, put a lot of time and energy into trying to make sure that patients and healthcare providers who are equally vulnerable after this decision, who were, you know, in many cases at risk of prosecution for providing healthcare to their patients. We did everything we could, and the Justice Department continues to, through a task force I was really proud to help launch, a reproductive rights task force, you know, help people navigate that. But look, you know, this is deeply personal to me and to my family, as I know it is to so many of you on this call tonight, and so many people across our state and our country. I think that, you know, a year ago, I was 20 weeks pregnant and we lost our son. I had access ultimately to the healthcare that I needed, but every single day, women in this country are denied access to that care. And it is extreme judges and politicians who are standing in between women, families, and healthcare decisions. It is wrong. And I will do everything in my power. I will fight with everything I've got. And I'm ready to fight this fight. I will never stop fighting this fight. I believe it is a fight that starts in Congress, because what we've got to do is we've got the Constitution and we've got common sense and public opinion on our side in protecting access to abortion in this country. The fight does not stop there. It really doesn't, because what we've seen is now access to contraception and to IVF, these things are at risk too. Congress has a central role, has actually the primary role in legislating these protections. And again, these are protections that existed based on Supreme Court decisions, interpreting the Constitution. We need to use every tool at our disposal, because unfortunately, we cannot, the Supreme Court is going to have its way with the Constitution, but it doesn't have a monopoly on it. And so I will work with everything I've got to advance the reforms that we need to see to restore reproductive freedom. And it's one, I think, that we're going to have to work in close partnership. Part of what makes me so excited about the possibility would be the honor of my lifetime to serve you in Congress and to represent you. It's a team sport, and it's going to require us at every level of government to work together, because this fight is not going to be a linear one, and it's not going to be an easy one. So to your question, I think the courts will continue to be an obstacle to justice, but I believe that sound legislation that's crafted carefully, and that is backed by people who believe deeply in it and who have skin in the game. This is where I believe representation really does matter. The House of Representatives is less than 30% women. And when it comes to this issue, I believe representation matters deeply.
So my two more questions. One is a kind of quick lightning round sort of question, and then I'll ask kind of a wrap-up question. The quick question is sort of one of the questions that came up through the chat is asking, what issues do you think are going to be coming before the Supreme Court in the coming term or the coming, next couple terms? What do we need to keep an eye out for or worry about?
Well, the hour is late, and I hate to cause anyone to not sleep, but I think, there are going to be a lot of really big issues every year that come before the court. But here's what I want to say about another reform effort that doesn't get enough attention, but that I feel really strongly about. So when I clerked in the Supreme Court, there were 7,000 petitions that came before the court that year. The court only decides 70 cases. So right now it exercises a whole lot of power over the decisions about what cases it should decide. And when you read the Constitution, there are only a small number of cases. They make a lot of sense. It's disputes between states, cases that involve, ambassadors and foreign officials. These are cases that are meant to be heard by the Supreme Court, and the Constitution protects that set of cases, but that's a tiny number. And otherwise, Congress has a really important role to play in helping to shape the kinds of cases that the Supreme Court hears. So I feel really strongly about this because I saw it firsthand working there, where we had 7,000 petitions come in. And traditionally, what had happened was all of the justices would pool together. And like I said at the beginning, each justice has 4 employees, 4 law clerks, who are tasked with reading. And this was some of the most important work for me on the court that year. You get so many handwritten petitions from federal prisoners, from people all across this country who are asking the Supreme Court for help. And every time I got a handwritten petition, and I spent a whole lot of time every week, because it's called the cert pool, and we're all supposed to chip in and write memos to help inform the justices in deciding what cases to decide. But every single time I got a handwritten petition, I thought about the Supreme Court's decision in Gideon versus Wainwright, which involved a state prisoner in Florida who wrote a handwritten petition to the Supreme Court asking the court to decide whether he had a right to counsel in his criminal case. And the Supreme Court took that case and made important law that has been so fundamental to the rule of law in this country and to basic fairness and justice. And so I spent a whole lot of time reading the handwritten petitions, but I can tell you that a lot of my colleagues did not. And there were two justices, and you can guess who they were, who did not participate in the cert pool. They didn't ever read, they didn't spend a minute reading any handwritten petitions. I think this is wrong. I think that Congress needs to step up and needs to really provide guardrails and rules of the road for how the Supreme Court decides the cases it's going to decide. Because every single term, again and again in recent years, we see the Supreme Court cherry picking cases that it shouldn't be hearing in the first instance. And so I know I didn't answer your question about what exactly we can predict hearing from the court next year, but one thing I can tell you is this is something I feel strongly about that should be part of Supreme Court reform, and something I'd want to work on starting day one.
Thank you. And then to wrap up, because I know the time is getting late, one of the things, and this sort of touches on some of the questions that have come in through the chat and some of your comments that you started this evening's discussion with. But one of the things that has struck me as we've talked about over the years, the consolidation of executive power and sort of the enhancement of executive power. One of the things that I don't think I quite appreciated with regard to executive power until Donald Trump was president was sort of the power of the executive to set a tone and a culture for our country. And for many reasons, not limited to the presidency of Donald Trump, but for many reasons, we are such a polarized country right now. We are so deeply divided. How, when it comes to engaging in civic dialogue, sort of restoring a commitment to democracy, how do you think you as a leader, should you be elected, how can you help us move forward to a better place where we can engage in robust conversation and move things forward in an active way?
Well, what gives me a lot of hope about Congress is actually the job that I left to come and run for this seat. So I was working at the White House. I was leading the president's unity agenda. And most of you have probably not heard a lot about the unity agenda because these days, unfortunately, disunity and division and conflict get a lot more attention than unity and progress do. But this is an agenda that has really got 5 big pillars, and it's rooted in the basic premise that as Americans, we can still come together and solve big challenges together. And they're challenges that require us to work together. So the five pillars that we pursued were tackling our mental health crisis, which, Justice Broderick has been on the front lines of that fight here in New Hampshire. And, this is an effort that we're seeing across the country, tackling our opioid epidemic, fulfilling our sacred obligation to veterans, ending cancer as we know it, and holding big tech companies accountable. So these are 5 big challenges, very broad ranging, rooted in the simple idea that as Americans, we can still come together to solve them. And there are 400 pieces of bipartisan legislation that were signed into law to advance the unity agenda. I'm very proud to report that the Supreme Court has not invalidated any of these important laws yet, and I don't think that they will. None of this is in litigation at the moment. These were substantive laws. They weren't the naming of a post office or the Refrigerator Freedom Act, which got time on the House floor recently, God help us. These were substantive bills. The PACT Act, which has done more to give veterans access to health care than any bill that has been signed in my lifetime. This gives me hope because, look, I do think that as Americans, there are challenges that we've got to define together and come and solve together. And, this comes back to really what I learned from my dad. He always said he got his education in the United States Navy. I did too. And one of the things I really learned was how to mute out the noise, focus on the mission, and work together with people who I might not agree with on much of anything at all. But look, I think that we've all got to be united. And one of the reasons that I really encourage you, and I hope you'll read the Constitution, because it is the common document that unites us all. And there are very few things that can truly unite us these days, but we've got to find them, and we've got to hold them close. And so that's what I think, and that's really the spirit that I want to work in this job, because it's not a popular time to want to go to the people's house, but to me it is an essential place for the future of this incredible project that we're all so lucky to be a part of, and that it would really be the honor of my life to represent you in Congress. And so I thank you for tuning in tonight. I really hope I can earn your support and that you'll join us. Megan, thank you so much for moderating this conversation. Thank you all for participating in the chat. I hope this is the first of many together. And Justice Broderick, thank you for being with us tonight. It's a real honor, and it's a real pleasure. And so I hope, I'll turn it back over to you, Megan, and to Sophie, but I really do hope we can continue this conversation, because it's a really important one.